You're standing on a public sidewalk. Maybe you saw something that looked like it needed to be documented. Maybe you were already filming something else when the situation developed in front of you. Maybe you just pulled your phone out because every instinct told you this was a moment that should have a record. Whatever the reason, your phone is up. You're recording. And then an officer turns toward you. Not toward whatever you were filming, toward you. And the expression or the tone or just the shift in attention, something tells you that the phone in your hand has just become the center of the situation. Put that away, or you need to stop filming, or maybe just a hand extended toward you, palm out, universal signal for stop what you're doing. And in that moment, with the phone in your hand, with whatever was happening still happening somewhere behind you, with an officer now focused entirely on what you're doing, what do you actually know? Not what you've heard, not what feels right, what you know, what is actually, legally, factually true about your right to record in that moment. Because here's the thing most people find out too late. The right to record police in public is real. It's established. It's been affirmed by federal courts across the country. But knowing that a right exists and knowing how to exercise it without losing your phone, without getting arrested, and without accidentally crossing the line from protected activity into something that's legally complicated, that's a completely different level of understanding. And that's what this video is about. The legal foundation first, because you can't hold a position you don't fully understand. The right to record police performing their duties in public spaces is protected activity under the First Amendment. Federal circuit courts across the country have consistently affirmed this. The right to gather information about how public officials exercise their authority, including by filming them, is recognized as falling within the First Amendment's protections. This isn't written explicitly in the Constitution. It's been established through case law over decades. The landmark case Glick versus Caniff from the First Circuit in 2011 is often cited, but the principle has been affirmed in multiple federal circuits. What this means practically, in most circumstances, in most public spaces, you have a legally protected right to record police officers performing their duties. An officer telling you to stop recording, in most cases, is not a legal order you're required to follow. I want to be careful about how I say that, because the legal landscape has meaningful complexity. Here's where it gets genuinely important to understand the limits. The right to record is not absolute. There are real, legally significant limitations. First, location. The First Amendment protection applies to public spaces, sidewalks, parks, public streets. On private property, property owners set the rules. If you're in a shopping mall, a private parking lot, a business, the owner's rules apply to recording, and an officer enforcing those rules is on different legal ground. Second, interference. The right to record doesn't protect conduct that interferes with an officer's ability to do their job. Standing on a public sidewalk at a reasonable distance and filming, protected. Getting physically in the way of an arrest or preventing officers from accessing a scene, not protected, regardless of whether you're holding a camera. The line matters, and it's a real one. Third, audio recording laws. This is the one that surprises people most. Video recording in public is generally protected, but audio recording, capturing conversations, is subject to state wiretapping and eavesdropping laws that vary significantly. Most states operate under a one-party consent framework, meaning you can record a conversation you're part of without notifying the other party. But a number of states require all-party consent for recorded conversations. If you're in a two-party consent state and recording an officer's conversation with someone else, that's a different legal situation than simply recording video. Know your state's specific laws on this. It matters. Fourth, seizure of your device. Recording something is one issue. What happens to your phone afterward is another. Under Riley v. California, police generally need a warrant to access the contents of your cell phone, even incident to an arrest. But your phone can be seized as potential evidence if there's probable cause to believe it contains evidence of a crime. Seizure and search are two different things. These limits are real. Understanding them isn't pessimistic, it's protective, because the person who knows both the right and its limits is better equipped to exercise it intelligently than the person who knows only one side. Now let's talk about what actually happens when an officer tells you to stop recording, because this is where most people's preparation ends. They know the right exists, they know they don't have to comply, and they have no idea what comes next. The request to stop filming can come for several reasons. Some are legitimate, you're too close and genuinely interfering with the scene. Some are legally questionable, the officer simply doesn't want to be recorded. Some are somewhere in between. There's a genuine safety concern that may or may not justify the specific request. Your response needs to work across all of those situations. And here's the thing, a response that's calm, clear, and grounded will serve you better than a response that's technically correct but creates unnecessary friction. Officer, I believe I have a First Amendment right to record in public. That's the phrase, said calmly, not defiantly, not as a challenge, as a statement of a legal position, offered clearly, without aggression. What you're doing with that sentence is several things at once. You're asserting the right. You're documenting on the recording itself that you raised this, and you're giving the officer the information that you know why you're doing what you're doing, which often, though not always, changes the dynamic. Now, what if the officer insists? What if the response is, I'm telling you to stop, and if you don't, I'm going to arrest you for obstruction? This is where it gets harder, and I want to be honest about the tension here, rather than pretend it doesn't exist. The right to record is protected. The arrest threat may not have legal merit, and an unlawful arrest is still an arrest. The physical consequence is real, even if the legal basis isn't. Fighting an unlawful arrest on the street corner is not the same as challenging it in court. Many attorneys who advise people on this situation say the same thing. If you're facing an arrest threat, the calculation shifts. The value of continuing to record in that moment versus the physical consequence of what happens next, that's a judgment call that only you can make in real time with the specific circumstances in front of you. What you should not do: argue extensively, escalate your voice, move toward the officer, or physically resist anything. What you can do: state your position clearly one more time. I want to note for the record that I believe this order is unlawful, and then assess whether continuing to record is worth what follows. This is not weakness. It's the recognition that the place to resolve this legal dispute is in court, not on the street. Let's talk about your phone itself, because this is a separate and genuinely important issue. An officer may ask for your phone, may demand to see the footage, may imply they have the right to take it. Riley v. California, a 2014 Supreme Court ruling, unanimous, established that police generally need a warrant to search the contents of a cell phone, even incident to arrest. This is a strong, clear protection. Can they seize your phone as physical evidence? Potentially, if they have probable cause to believe it contains evidence of a crime. That's different from searching its contents. Seizure is one thing, access is another. You should not voluntarily hand your phone to an officer. You should not unlock it for them. If there's a question about footage on your phone, that question gets resolved with proper legal process, a warrant, a court order, not by you handing it over because you were asked. I don't consent to a search of my phone. Clear, calm, once. If it's seized over your objection, state clearly, I want to note that I'm not consenting to this, and then let legal process handle what happens next. One more thing on this. Do not attempt to delete footage while an officer is present or while your phone is being discussed. Deleting potential evidence creates a different and significantly more serious legal problem. Whatever is on that phone, leave it there. Let me give you the complete practical toolkit. Because knowing the concepts without having the specific words ready doesn't help you when the moment actually arrives. When you're recording and an officer addresses you about it, "Officer, I believe I have a First Amendment right to record in public," said once, calmly, not as a confrontation opening, as a clear statement. If asked to move back or give more distance, "I'll give you some space," and then do it. The right to record doesn't require standing close. Moving back to a reasonable distance while continuing to record preserves the right without creating the interference issue. If ordered to stop recording and you decide to comply for safety reasons, you can stop. That's a choice you're entitled to make. The right exists whether or not you exercise it in every moment. If asked to hand over your phone, I don't consent to a search of my phone. If your phone is being seized, I want to note that I'm not consenting to this. If you're told you're being arrested for recording, comply physically. State clearly, I am complying with this arrest. I want to note that I believe this arrest is unlawful. Then immediately request an attorney. Scenarios. Because the public sidewalk encounter is one version of this and there are others. What if you're recording from inside your car during a traffic stop? You have the right to record the interaction from inside your vehicle in most circumstances. The dashboard camera has been running. That's recording. Your phone camera pointed at the officer at your window. That's recording. The officer may ask you to put the phone down. You can acknowledge the request and state your right calmly. Whether you continue recording at that specific angle during a traffic stop where you're legally required to cooperate is a judgment call, but the right itself doesn't disappear because you're in a car. What if you're recording from across the street and an officer approaches? You're on public property at distance, not interfering. This is the cleanest version of the protected activity. Officer, I believe I have a First Amendment right to record in public. Hold your position. Don't move toward the scene. What if someone else asks you to stop? Not an officer, but a bystander or someone adjacent to the scene. Private citizens cannot compel you to stop recording in public spaces. You're polite about it, but you're not legally obligated to comply with a private citizen's request that you stop documenting something happening in public. What if you're recording and the officer says the area is closed to the public for an operation? If the public space has been legitimately secured as part of an operation, and your presence in that secured area is being questioned, that's a different situation from simply recording in open public. Officers can establish perimeters. The question of whether the perimeter was lawfully established and whether your position was within it is something that may require legal examination afterward. In the moment, comply with instructions to move, document that you're doing so, state your right clearly once, and address the legal questions after the fact. What if you're recording an incident involving someone you know, a family member, a friend, and you become emotionally escalated? This is the version where the most mistakes happen. When someone you care about is in a difficult situation and you're recording it, the emotional state that comes with that can override the careful approach that protects you. The recording you make only helps if you're still there to present it. Getting arrested because the situation became emotionally heated means the recording may end up seized, may be inaccessible, may be in a legal process that takes months. The most effective thing you can do in that situation is stay calm, keep distance, keep recording, and stay free. Your presence as a witness with documentation is more valuable than your presence as a second person in the situation. Here's what I want to leave you with. The right to record police in public exists. It's real. It's been established through meaningful legal precedent. Knowing about it is important. The ability to exercise it effectively, with the right phrases, the right distance, the right understanding of where the limits are and what to do when you're pushed. That's what actually protects you when the moment comes. These two things together are what gives you a clear head when your phone is up and an officer turns toward you. Not a confrontation, not a legal argument on the sidewalk, just a calm, clear, informed person stating a known position and holding it steadily until the situation resolves. That person gets to keep their footage, gets to go home, gets to provide documentation if it matters later. Practice the phrases, know the limits, stay at distance, stay calm. But here's something worth sitting with as we close this out. We talked about recording police. What about when the recording goes the other direction? What about when the surveillance isn't coming from you? When license plate readers, public cameras, or data collection tools are creating a record of your movements that you had no part in making and may not even know exists? The legal framework around passive surveillance, information gathered about you without any active interaction, is a different and genuinely underexplored area of rights awareness. Most people assume surveillance only matters if they've done something wrong. That assumption is worth examining.